SwayamPrabha. Digital India. Educated India.
I am Devojit Kumar Sharma. I will be discussing with you today the topic on victims' rights in India. This particular lecture is as part of the course on Criminology, Penology and Victimology. As you may be aware that India follows an adversarial system of criminal justice. One of the important tenets of adversarial system is that an accused is presumed to be innocent until proven guilty. Now, if that is so, is it that the victim is guilty or in all cases are more or less frivolous or false cases? I mean, that may be one of the assumptions. If you all the time presume that the accused is innocent, that means we can also have a assumption that is the victim who may be guilty. Is it so? But it is not like that. Nobody knows whether the accused is really guilty or not. Nevertheless, the victim must have suffered some injury or loss by the acts or omissions on the part of the accused. So, therefore, friends, what is important for us to realize that both the parties are equally important, but the system that we follow, it is commonly perceived that it is more tilted towards the accused, because there is the presumption and which is an essential component of Article 20 and 21 of the Constitution of India. And it is also that not only the accused has to be presumed to be innocent, but the guilt has to be proved beyond reasonable doubt. That cannot be substituted by the standard called preponderance of probability. Now, so much of kind of liberty or so much of normative consideration is given to an accused in a criminal trial. In the process, people sometimes feel that maybe the victim is completely ignored in the entire process of criminal justice. As I have said, that is not the case. In the laws that we have in the country, the victims have also been equally taken care of. But unfortunately, it is very difficult to identify wherein in the statutes the rights of the victims have been mentioned directly or indirectly, and how the courts have been interpreting the rights of victims from time to time. Let me tell you the fact that it may so happen that the rights of victim as such categorically may not be mentioned, or it may not find mention, say for instance in the Code of Criminal Procedure in every section of it, be it at the stage of investigation, trial, then after the acquittal, conviction, imprisonment. In all the sections, every time the victim rights may not be explicitly stated, but then we have to identify, and we also have to rely on the judgments of the courts from time to time to understand where are the victims' rights accommodated. As I have said, let us not go with the perception that it is the accused who is given all importance in the criminal justice system. That is not the case in India and also in other Commonwealth countries which have adopted adversarial system. But nevertheless, we cannot also ignore the fact that victim is given more importance in comparison to the adversarial countries in the inquisitorial countries. And France is a very good example of it. We are going to discuss about the victim's participation in criminal process in France, how very closely and intimately the victim participates in the criminal process. But unlike the inquisitorial countries like France, the countries like India do not have similar system in place, but that does not necessarily mean that we do not have rights for the victims. We do have very important rights, not only when it comes to compensation to the victims, but starting from the very stage of investigation itself, what we are going to see one by one today in the lecture. What is commonly known so far as victims' rights in India is concerned, some of the important judgments of the court, Supreme Court and the High Courts from time to time, wherein the court directed the state or at times the individual to pay victims compensation or to pay compensation to a victim, may be at the stage of trial, interim compensation, may be at the end if the person is finally found guilty of having committed an offense. Now, these are there at the stage of at the level of compensation, but then victims' rights does not stop or it does not end there, neither it kind of culminates only in the compensation aspect. It has got different parameters to look into so far as the victims' rights are concerned. As I have told you, at every stage of criminal justice administration, there are sufficient, though may not be to that extent that we have in the inquisitorial system, which is perhaps not possible, because we have this particular model that we have adopted, that is called due process model. In the due process model, what is important is that the process has to be followed. The person is not presumed to be guilty, because the process does not allow us to do it. At every stage, there are certain impediments towards giving the accused an impression that he is guilty. No, that is why we have number of checks and balances. It is important to note here that the adversarial system is dependent on the fact that the means will justify the end, not that end justifies the means. That means, the procedure is very, very important so far as our administration is concerned in criminal justice. Therefore, generally it is seen that accused is given more of normative consideration at every stage, even at the stage when he or she is being imprisoned, because we have number of discourses which are there from human rights perspective so far as prisoners' rights are concerned. One might feel, why so much of importance is given to such people who have offended or who have committed wrong? Now, are there no other priorities for the government or the state to take care of, rather than only taking care of the people who have committed crime or who have kind of committed offenses? But it is not like that. If you go back to the various theories of crime causation and the schools of criminology, you will realize that people do not commit crime all the time out of their own volition. There might be circumstances compelling them to commit crime, because of which the law and the justice administration always very liberally takes into consideration those antecedent, precedent and circumstantial factors into consideration while imprisoning someone, while convicting someone, and also to ensure that people are sufficiently integrated back to the society. Now, that much of importance is given to an accused, and if the accused is finally proved to have committed the crime also, when he or she becomes a convict, when he or she is has to live in the jail or the prison, at that stage also it is so required that the accused or the convict may have to pay compensation to the victim. Now, in this particular backdrop, if we try and understand the victims' rights in India, that will be very useful for us. Let us not go with a perception that victims have got no rights in India. No, victims have got sufficient rights, but then it may not be to that extent as I have stated in comparison to the inquisitorial system, and the reason being also what I have just mentioned, because we have certain processes to be followed, and those processes are more in terms of normative consideration for the benefit of the accused, because no one innocent person should be punished, let 99% of the guilty be scot free. That is the very common saying about the criminal justice system that we have. No innocent person, not even 1% of the innocent should be punished. Let 99% of the guilty be scot free, because this is something that we believe in. This is the process that we have developed, due process. We do not go with the crime control model, about which we will be definitely discussing in the next lecture that we have on the criminal justice system in India. But in today's particular discussion, we will be focusing on the victim's right that have been laid down in the statutes, that have been laid down in the Code of Criminal Procedure more precisely, and the decisions of the court from time to time on such rights. That is what we are going to look at in this particular lecture. As I have just now mentioned to you, that victim has got right at every stage of criminal process in India, and that is what I am going to do for you. They very importantly, the word victim is defined in the Code of Criminal Procedure. The section is section 2WA, Code of Criminal Procedure. Now, it defines victim as one person who suffered loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. That means, the word victims finds mention in the Code of Criminal Procedure itself, and what it has stated, or what the definition says is that the loss or injury suffered, the person who suffers loss and injury, not necessarily that the person has to be the victim, even his legal heirs or the guardians can also be categorized to be defined as a victim, because at times what happened, the victim may not survive after the crime is being committed. The victim might have been killed by the acts of the accused, and it is important that the word being used here in the definition is when the person is charged. That means, so far as definition of Code of Criminal Procedure is concerned, unless the person is charged with the offence, charged means whatever has been charged by the police, maybe in the form of a charge sheet or otherwise, you cannot call the victim as victim so far as the Code of Criminal Procedure is concerned, or so far as the criminal process or justice administration in India is concerned. But he or she may be a victim otherwise. But if you go with the very strict interpretation of this particular definition, you may also realize the word loss or injury that finds mention in the code in definition is not being defined. What is loss and what is injury? Who defines it? Legislature has perhaps left it to the wisdom of the courts to define what amounts to loss and what amounts to injury. But if you look at the UN definition of victim, it categorically defines what loss and injury amounts to and what loss and injury stands for. The UN definition says that mental, physical, economic or even violation of fundamental rights amount to that loss and injury. That means, any aspect of the victim can be categorized as loss and injury. That is what is given in the UN definition. Now, UN definition also recognizes the persons who assist in preventing a particular person from victimization. That means, not only directly the person who suffered injury or loss, but also if anyone happens to assist the person assist the person in preventing victimization, even that person is categorized as victim, so far as UN definition is concerned. So, in a way, one can say that there is still scope for CRPC to further expand or further make the definition of victim more inclusive by defining what amounts to loss or what amounts to injury. Importantly, this definition was not in the original CRPC. This was inserted by an amendment made to it in the year 2009. Another very important section, so far as the criminal process or the criminal justice in India is concerned, the FIR, the first information report. That is something given under section 154 of the CRPC. What we have today in the Code of Criminal Procedure is that the FIR, the statement given by an informant, after the statement is given, is to be also read out to the informant by the police. That means, if anybody goes to a police station and lodges an FIR, it may so happen that the person gives one statement and the police officer in charge of the police station records his statement in a different way. There are probabilities or possibilities of similar kind, so that there may be a discrepancy, there may be a difference in the statement being given and statement being recorded. To avoid similar situation, what is being laid down is that every such statement has to be read out to the informant. Now, in a way, if we see this particular section from the perspective of victim's right, now an informant may also be a victim. That is a different thing altogether, that in the new criminal law that we have in the country, it has been separately mentioned not only informant, but also the victim. That is a separate thing altogether. But till the time this particular new criminal law comes into force from the 1st July 2024, let us appreciate the fact that it is not that victim is not to be informed what is being recorded by the police, but the victim has to be in fact informed, that has to be read out. In a way, we can interpret this section also as a component of victim's right, because the victim also gets an opportunity to know what the statement or manner in which the police has recorded the statement. Now, earlier what used to happen, so far as 154 CRPC is concerned, the registration of FI was not mandatory. If somebody lodges a complaint or into the police or goes to the police were not bound to register an FIR in every case. Maybe whatever reasons could be because of different consideration, but now after the Supreme Court ruling in this connection, it has become a mandatory requirement for the police to register FIR. It is a different thing that after preliminary investigation, if nothing credible is there, that particular case may be closed by the police. That is a different thing altogether. But registration of FIR cannot be refused by the police so far as section 154 is concerned. That is the ruling of the Supreme Court. Now, as I have told you, this particular section is in existence today, but one of the very important changes that the Bharatiya Nagarik Suraksha Sanhita 2023 has mentioned is that a copy of the information as recorded under this particular section, and in the case of Bharatiya Nagarik Suraksha Sanhita, it is section 173 instead of section 154. It has to be furnished, or it has to be given to the both informant as well as to the victim free of cost. That means, now the change that we are going to see is not only the informant, but it can be it is also the victim, whoever may be. Because what happens in case of crimes, either I myself go and lodge an FIR, I am the victim. Second situation can be, I do not go myself, but then somebody else goes to the police station and lodge an FIR on my behalf. I may be an informant, but then I may not be a victim as such, but there is no any hard and fast rule that the informant cannot be the victim. I may be the victim as well as informant both, I mean one who informs to the police. And the third situation is that police themselves so moto can take cognizance of such cases and lodge an FIR. But in the first and the second cases, the Nagarik Suraksha Sanhita has very categorically stated that a copy of the FIR has to be given both to the informant or the victim. That means, they have specifically mentioned about victim, and that is a very, I would call it a very good change that is being inserted in this particular section. Now, beyond that, what is being laid down is in 173, the new section, that the victim has to be kept updated about the progress of investigation. Now, in cases which are punishable with imprisonment beyond 7 years, before the state ask the prosecution to withdraw the consent of the victim, or the victim has to be heard on such cases. This is what is the scheme of the new provision, or what is being laid down in a Sanhita. I feel that is a very important progressive kind of change altogether in the new law. Now, the proviso to 154 CRPC, I have already told you about the registration of FIR under 154. Now, the proviso to it also provides that in case the offences offences of the nature of section 326A, 326B, and any offence related to criminal force or sexual assault, which is alleged to have been committed against the victim. Now, the police officer, and not only the police officer, a woman police officer, what is being categorically mentioned, that woman police officer has to record the statement or record the information at the informant's residence or any other location that may be convenient to that particular informant. Now, that is the aspect of right which is involved. So far as the victim's right is concerned, though the word victim right may not be very explicitly mentioned in the proviso, but is being provided that in such cases, it is not that the person concerned or the victim has to come to the police station. No, the police officer is duty bound to record the statement at the residence of the informant, or if not the residence, at any other place that may be convenient to the informant. Now, very interestingly, the new criminal law, that is the Bharatiya Nagarik Suraksha Sanhita, further provides that in cases of rape, where the allegation of rape is there, not only that woman police officer will record at the residence or any other convenient place, but also that should be done in the presence of the parents, relatives, or any other social worker of that particular locality. And such statements may also be recorded through audio visual means, including mobile phone. That means, with the advancement of technology, when we have similar facilities like the mobile phones and the audio visual things, why is that the person has to reveal his or her identity. It is not required. Now, the moment the woman comes to the police station, it may so happen that the people will come to know who the victim is. There could be number of questions. People might even at times doubt the integrity of the person concerned. To avoid all that, and also that the person may be under a lot of fear, trauma, the person may be traumatized after incident of rape that might have happened with her, and she has been victimized for no fault of hers. There are so many cases. Now, in such situation, the law does not want that the woman should come to the police station. Rather, the law directs that the police will go to woman's place or any other convenient place. Now, if at all required, there may not be any physical contact between the police officer and the victim. It can also be done through mobile phone. That would be sufficient, and that would be FIR for the purpose of section 154. Nothing more is required to be done. And this is of course, the new change only pertains to the cases of rape exclusively, and that is what is provided under section 176 of the Sanhita. Similarly, in the CRPC we have section 164, which requires that any person victim of rape needs to be examined by medical officer, registered medical officer. The new section in the Bharatiya Sanhita, this particular Suraksha Sanhita 2023 is that what is being inserted here is that with the consent of the victim or with the consent of such woman or person. Now, we need to also understand why these two words have been inserted, woman or person. What is the difference between both? Now, the difference is that every case of rape may not be informed by the survivor of that rape case or the victim herself. It may so happen that there could be a close relative who gives the statement on behalf of the victim. Therefore, the words being very carefully kept as the woman or a person competent to give statement, but what is also being laid down that the consent on behalf of that woman, that is important. There is a new change that has come in. The consent is important, and not only that, the medical practitioners are now duty bound to examine similar victims of rape cases within 24 hours of the occurrence of the incident. That is one of the drastic changes, I would call it. Within 24 hours, the person has to be medically examined by a registered medical practitioner. More than that, what the new law also provides is that within 7 days of that examination by medical practitioners, report has to be sent to the investigating officer, which shall further be submitted before the magistrate. I mean, these timelines have been given so that the victim is not further victimized at the police station. Otherwise, cases will keep on piling and the victims will keep on waiting. And in the process, the very interest in the criminal justice system gets diluted, it is lost on behalf of the victim, and many of the guilty people are scot free because of procedural infirmities and procedural lapses. Now, as expeditiously as possible, because these cases have to be dealt very seriously, meticulously, and that too within a prescribed time limit. That is what the new change that is Suraksha Sanhita is trying to bring in the procedural law, in the criminal procedure in the country. Now, you also may be aware about the fact the CRPC also provides in section 154 subsection 3 that in case a police officer refuses to register an FIR, if somebody goes to a police station, now the informant or the victim can even directly go to the superintendent of police, the SP of that particular district. No police officer in charge of a police station can refuse to register an FIR. In case if it is done, the person has got every right by virtue of section 154 subsection 3 to approach the SP of the district concerned, and by examining the particular case, SP himself can take cognizance in place of the IO, in investigating officer, and he may also direct any other police officer to further investigate on the case. Now, this is about the investigation by the police. Now, the investigation is not only limited to police, where we have seen that the victim's rights are being, to some extent it's being considered. It's not that completely victims' rights have been ignored. Now, there is another very important component in the CRPC is that even the magistrate can take cognizance of cases under section 190 of the CRPC. Now, on what grounds? If the magistrate receives any complaint of facts which constitute such an offence, or upon an information received for any person for that purpose other than a police officer. In all this situation, we have this particular provision in CRPC 190 which gives the power to the magistrate to take cognizance of such cases. So, it is not only that in cognizable offences the police can take cognizance, even the magistrate can also take cognizance, say under section 190. Now, it is not only that magistrate can take cognizance, magistrate can also further investigate on such cases. What is the section? This section is section 156 subsection 3. Now, it provides that it is not, it provides that any magistrate empowered under section 190 may order an investigation. That means the magistrate is also empowered, and very clearly this needs to be understood. It is not essential that magistrate would investigate each and every case, but what is the very connotation of the word empowered here is that the magistrate has got the power to order investigation wherever necessary. So, what happens is that wherever there are cases when the police officer refuses to register an FIR, when an informant or victim goes to a police station, that person can also approach the magistrate, who can take cognizance by virtue of section 190 of CRPC, and by virtue of section 156 clause 3 of the CRPC, the magistrate can also further order investigation on such cases. Now, so much of protection is given to the victim of a crime, so that at the very inception of criminal process should have no concern, or it should be more inclusive not only to an accused, but also to an victim of crime. Now, in the landmark decision of the Supreme Court in Sakeri Vasu versus State of UP 2008, it was held that in cases where the magistrate finds that police has not done investigation or its duty of investigation properly, or has not done it satisfactorily, in such cases the magistrate can exercise power under 156 subclause 3. That is what the Sakeri Basu versus State of UP, it was held by the Supreme Court. Now, Even beyond that also, if you look at section 173, subsection subclause 8, what you will find is that the police officer investigating a particular case has got the right of further investigation if the situation so demands. That means, even the power to further investigate on a case, but it should so happen that by the same investigating officer. There cannot be change in the person who is investigating or the IO who is investigating, otherwise it would amount to reinvestigation. Now, reinvestigation can only be allowed by the court, by the High Court, but in cases of necessity, where there are more evidences coming in to the police after filing of the charge sheet, that is the police report, that is what is 173 of the CRPC talks about, that the filing of the charge sheet by the police in the court. Even after that stage also, further investigation is allowed, subject to the intimation or subject to the permission of the court. That means, the police has to seek permission from the magistrate concerned, that in such a such case more evidences are coming in, may I be allowed to further investigate this case. In such cases, magistrate can allow the IO to further investigate, and subsequently the police can further submit such reports after even filing of the charge sheet also to the magistrate concerned. That is the scheme of the act. So, in a way we can see and realize here is that there are sufficient kind of normative consideration towards the victims or the victim's right, so far as the process of investigation, so far the powers of police are concerned, which are there as part of the CRPC, and which are of course also intended to be brought in by virtue of the amendment of the CRPC. Now, an important change that happened in 164 of the CRPC after the infamous Nirbhaya case in Delhi, that in 164 CRPC, that is the statement to be recorded by a magistrate. As we know that under section 161, any statement given by an witness before the police has got no evidentiary value, or it is more of a only to the extent of contradiction or checking the veracity of the witnesses, that is there, but then that is something that 164 deals with, that only statements given to a judicial magistrate will have evidentiary value in the court of law, and that is a controversy between 161 and 164 that we are going to deal in detail as part of our next lecture on criminal justice system. That why is it that, what is the reason for retaining 161 if what is being stated before police has got no evidentiary value in the court of law? Why not we club 161 and 164 together? That is what the some of the kind of practitioners they sometimes point out, and even police people they sometimes point out that if ours, what we have done is not having any value in the court of law, then why should we do it? Can't 161 and 164 be clubbed together? But that is a different issue altogether. But what happened after the 2013 Nirbhaya case incident, that a particular subsection 5A was inserted to section 164, and which states that, or which made it compulsory that any statement of a rape victim or any other sexual offences should be recorded by a judicial magistrate. I mean, that means this was an amendment that happened in 2013, but what was the situation before that? The situation before that was that any statement to be given by a rape victim or sexual offences was to be, or it was indeed recorded by police only. That means that is under 161. Now, rape victim has to go to a police station or the police people coming to their homes, but again after that stage also there is further victimization, is that the person has to go and stand in the court revealing their identities, that see, I have been raped, I have been sexually assaulted, this crime has been committed against me, and also present herself in the in the particular place in the court where there is cross examination of witnesses. That was the humiliation that victims had to suffer, at earlier times, but then now things are different. Now what is being provided is that the judicial magistrate will directly, without allowing the police to do it, they will directly, or the statement have to be recorded on such cases. Further, the veracity of such statements cannot be further contested, because these statements have to be given on oath. Since it is given on oath under the Oaths Act, it has got evidentiary value in the eyes of law also. Now, it is further provided in another section, subsection under this particular section, that judicial magistrate shall record statements of the victims or the informant in cases of 376D, 376C, 376DA, 376DB, section 376E and 509 of the IPC, as soon as possible or as soon as the commission of the offence is brought to the notice of the police. That means there cannot be even laxity, or the magistrate cannot wait for things to further go wrong. They have to record it as soon as the commission of the offence is reported. Now, such statements given to a judicial magistrate, it is further provided in the proviso that may also be considered further for the purpose of cross examination. There is no requirement of further cross examination in the court of law. I mean, is it not something to do with the victim's right? I think it is so. There is no need. I mean, it is not that things have always been there as part of our statutes, but the things are happening now. Rights have slowly been recognized through the amendments to the Supreme Court judgments and the High Court judgments by inserting such similar changes in the statute book. So, that would be the statement given to the judicial magistrate for all purposes will be considered as cross examination also. Now, when I am talking about the investigation part to you, it is not that the victim has got no right at the trial or at the other stages. That is we are going to talk, but in between let me take you to one example that happens in France. I have mentioned to you at the beginning. Now, what happens in France is the victim has got an active role both at the stage of investigation as well as at the stage of presentation of testimony to the court. I mean, the strict evidentiary rules which are followed in a country like India is not followed in France or maybe some other inquisitive countries also, because it is the judge who decides what is true and what is not true, because their whole emphasis is on truth, whereas our emphasis in the system that we have followed is on proof. Either it is a quest for truth or the quest for proof, rather it should be the quest for justice as a whole. But the system that we follow is we always go for finding the proof, even if we know that this is the true, this is the person who has committed wrong, he is the criminal, but then lack of proof, lack of evidences may sometime lead to acquittal of the criminals or acquittal of the real culprits of the crime. But that is why in inquisitive countries like France, what happens is that the victim is given all liberty, and a victim is a very much important component of the entire process of criminal trial, starting from investigation till the stage of testimony in the court. And moreover, the silence on the part of the victim may also be seen as an incriminating factors and victim's involvement in the crime. Now, then comes the stage of bail. Does victim has got a right at the stage of bail? Now, section 437 CRPC, when bail may be given in case of non-bailable offences, it is being stated that no bail shall be given in cases of death, imprisonment for life or imprisonment of 7 years or more, the cases pertaining to those offences without giving an opportunity to the prosecution or without giving an opportunity to be heard from the prosecution on such cases. That means the public prosecutor has to be heard whether the benefit of bail has to be given or not, so far as section 437 CRPC is concerned. Now, what is the meaning of prosecution being heard? That it means that the victim has to be heard indirectly. Now, prosecution represents the state and state is representing the victim. So, indirectly victim has got a right to be heard in cases which are of the nature of which are punishable up to death, imprisonment for life or imprisonment of 7 years or more, to be heard on the question of bail. Now, it has also been inserted by an amendment in the CRPC in 2018 that the application for bail has to be given to the public prosecutors within 15 days of the receipt of notice of such application in serious offences like 176 AB, 176 DA, 176 DB and so on and so forth. That means rape cases. Within 15 days that information or the public prosecutor has to be informed that what is the opinion, what the public prosecutor has to say, and the victim can very well say what she has to say with the help of the public prosecutor. Now, there are number of important judgments so far as victims' right to bail are concerned. One is the Guru Saran Singh versus Delhi administration, that is an old case of 1978, which is commonly called as Sundar murder case in Delhi, and he was perceived to be a threat to Sanjay Gandhi. Now, in that particular case, the court has stated that the question of bail has to be considered or has to be considered by the court depending on facts and circumstances, or whether allegations against the accused are prima facie true, statement of the witnesses and other material factors have to be taken into account on the question of bail to be given or not to be given. Now, in the Hariram Bhamvi versus Satya Narayan 2021 case, this was a case pertains to prevention of atrocities against silk caste and silk tribe. Now, in this case, the court held it is not sufficient that the person is being person is being released on bail. Of course, that is a right of an accused, but equally it is important to take into account what is being laid down in the CRPC, that the public prosecutor has to be given has to be heard. That means, without hearing the public prosecution on the question of bail, no bail can be given. In case if bail is granted, that is a procedure left on the part of the court concerned. And in this case, the bail was given by stating the reason that under the facts and circumstances of the case, which the court said it is a complete error. It is a wrong way to reason that the bail is granted depending on the facts and circumstances. That can never be the ground for granting bail. Rather, the ground for granting bail is very much implicit in section 437 CRPC, which says that public prosecutor has to be heard. Now, as I have told you, this is something to do with the victim's rights indirectly. Now, victim's participation during trial, it is not that once the investigation is over, victim has got no role to play, or he has got or she has got no right in a criminal justice process. No, the victim still has got right in the trial process. As you may be knowing that in the case of Rajesh versus State of Haryana 2013 case, what was held by the Supreme Court is very important, which has been reiterated by the Supreme Court in the case of State of Jharkhand versus Shailendra Kumar Rai also, that two-finger test of rape victims cannot be allowed. Earlier the practice was that this two-finger test, whether rape has actually happened or not. Now, in this 2013 judgment, the court court stated that application of this test is violative of the human rights and the dignity of the person concerned, and that is something cannot be permissible, it is not permissible, and that is also something infringement on the privacy and the physical and mental integrity of the person concerned. Now, same thing was also reiterated by the court in the case of State of Jharkhand versus Shailendra Kumar. Now, second case that is important to be looked into here is that Nipun Saxena versus Union of India 2019 case. Now, the identity of the rape victims cannot be disclosed at any stage, failing which may also lead to criminal offence under section 228 of the IPC. Now, even if a rape victim wants to appeal to the superior court, her identity should be not disclosed, or she may represent herself to be X, Y and such and such. And it is also being laid down in that particular case that even the criminal justice functionaries are not supposed to be compromising with that very identity of the victim, otherwise that would amount to another criminal offence on the part of the functionary. Now, the next important aspect, after the investigation is over, trial is over, now it may so happen that the victim wants to appeal against the particular judgment of the court. The victim has got right of appeal also. This is something that is being laid down in section 378 of the CRP, 372 of the CRPC. Now, 378 is something different that actually requires that leave of appeal should be taken from the High Court. That is something related to this. But my point here is 372 allows any victim to file an appeal in a court which is usually, or where a leave may usually lie, or where a appeal may usually lie. And this is something that was held in the case of Mallikarjun Kodagil versus State of Karnataka 2019. What was held in this case was that the victim has got an unrestricted right to file an appeal or prefer an appeal under section 372 of the CRPC, and no further leave of appeal is required to be taken under 378. That means, unlike in other cases of 378, under 372, there is no need for further permission to be taken from any other court for the purpose of filing an appeal. And that too, what this particular State of Karnataka case held was that on 3 grounds, if the victim feels. Number 1, if the victim feels that the person, the accused, has been acquitted falsely. That means, there is a prima facie case, but then the person has been acquitted, not convicted. The victim may file an appeal. Second is, the victim has been given inadequate punishment. That means, the imprisonment may be lesser than what the victim prefers or victim feels. In such cases also, victim may file an appeal. And thirdly, in the cases where victim might feel that the compensation being awarded by the court is inadequate, in such cases also the court can admit an appeal from the victim, and that is the very judgment decision in this case of Mallikarjun Kodagali versus State of Karnataka. Now, as we know that the victim compensation is something that is well known, we all discourse about. You have section 250, 357, 356 CRPC. You have the Provision of Offenders Act, under which the compensation can be granted to a victim of crime. You have 1402, 144 Motor Vehicles Act, where the compensation aspect is being taken care of. You have the Protection of Human Rights Act 1993, where victim compensation is being mentioned. Now, you have Article 21 and 38, which enjoins upon the state to pay victim of any state atrocities or to pay compensation to the victim, that is under Article 21 and 38 of the Constitution, that is very much there, implicit. Now, this would be perhaps the last thing that I wanted you to know about victims' right, that we have number of judgments of the Supreme Court and the High Court where victim compensation has been highlighted. And in these cases, what the court says was that 357 of the CRPC should not be construed very liberally, or it should be construed very liberally, and compensation should be given to the victims of crime. That was the case of Hari Shankar versus Sukhbir Singh, 1988 case. Now, in Buddhiswata Gautam versus Subra Chakraborty case, AIR 1996, it was held that the compensation can not only be given after the person is found guilty. The court held that compensation can also be given as an interim measure. Even during the pendency of the trial also the compensation can be given. That was held in the Subra Chakraborty's case, because in that case there was a sexual intercourse between the two persons, and the person person had to undergo woman had to undergo 2 abortions. After that, she was deserted by her husband, by this particular person, Subra Chakraborty, and he refused to marry her. Now, in the Jacob George versus State of Kerala case, the woman died after being aborted, while she consented for an abortion, but in the process she died, and the court directed the state to pay compensation to the next of kin. That means compensation to the son of that victim was given by the court, and it was the particular sum of money was fixed by the court to be paid to the son of that victim. You have, because since the time is less I cannot go on, but you have other very important cases such as Rudol Shah versus State of Bihar, where the compensation was given for illegal detention for 14 years. You have PUCL versus State of Bihar, where the compensation was given for payment was given because there was unwanted firing by the police, killing around 20 people including children, 21 people. You have Nilavati Behra versus State of Orissa, where compensation was given because there was custodial debt, and in this case it was held that sovereign immunity cannot be to the extent of torturing people, and Supreme Court was very much clear about it, no custodial debt can happen. So, to conclude, we can say that there are legal provisions, there are important decisions of the courts pertaining to victims' rights in India, and these have to be identified. Though the law may not all the time be very clear about victims' rights, but same can be construed, same can be interpreted, same can be identified within the scheme of the CRPC, within the decisions of the courts, and also more importantly what we have the new law, perhaps it is more promising so far as victims' rights in India is concerned. Thank you so much.